Please be seated. We have one case on the docket scheduled for oral argument this morning. Following the oral argument, we will remain on the bench for a question and answer session with students from the University of West Florida. If your schedule is permitting, we ask the attorneys to remain with us for the Q&A session. Our first case scheduled for oral argument this morning is Katherine Herman, personal representative for the estate of Steve Herman versus Nancy Herman Bennett. Counsel, ready to proceed. You may approach, counsel. Counsel will schedule 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, please. If I could reserve 5 minutes for rebuttal.
So noted, counsel. You may proceed.
May it please the court, my name is Sarah Rummel, speaking on behalf of Katherine Herman, the personal representative for the estate of Steve Allen Herman. The issue to be determined by the court today is whether the lower tribunal properly applied the Florida Rules of the Florida Rules of Judicial Administration, Rule 2.514, to Florida Statute 733-702. Specifically, to begin the creditor's claim period the day after the date of first publication instead of the date of first publication. The facts of the case are as follows. On January 4th of this previous year, 2018, the personal representative first published the notice to creditors in the Gainesville Sun on January 4th. The personal representative further sent notice by certified mail to the appellee. On April 4th, the creditor's claim period ended. That's 3 months after the date of first publication. The claim was filed against the estate on April 5th. The personal representative moved to strike the claim as untimely on April 9th, and on May 2nd, the lower tribunal ruled that the claim was timely by applying Florida Rules of Judicial Administration, Rule 2.514. In so doing, instead of beginning the 3-month creditor's claim period upon the date of first publication and ending it 3 months later, she began the 3-month window on January 5th and extended the 3-month period by 1 day.
Can I ask a threshold question about jurisdiction and specifically about our jurisdiction here? Your brief, you cited subsection 18. Is there any other basis for our jurisdiction, or is that it? And the reason I'm asking is it says determine a motion or petition to strike an objection to a claim, and that's not what this was, right? This was a motion to strike the claim itself.
This was a motion to determine the claim as being untimely.
Right.
And because the judge interpreted the statute, we felt you had de novo review over her decision because she applied, it was a decision of law instead of fact, and by refusing to strike the claim as untimely, she made a final determination that the claim was in fact timely. And so under the probate rules, that is considered a final judgment and is appealable to the First District Court of Appeal.
So it's considered a final judgment because it's determining that the claim was timely? But if the timely claim leads to no proceeds or no distribution, or it could be timely but invalid for some other basis that then would not require a resolution of this issue ever. Is that right?
So if the claim is determined to be timely and we have still objected to it, then a separate action would be filed, which it was. But since we have appealed whether the claim was actually timely as opposed to being untimely, that case can't move forward to determine whether or not it is a valid claim against the estate until we have determined first the issue of whether the claim was timely.
No, I understand that from a practical standpoint, but I guess I'm specifically asking about the rule that lists the specific issues of probate that can be appealed here as a non-final order. And the one I guess at issue, it says determine a motion, this is B18, determine a motion or petition to strike an objection to a claim. So that would be, I guess, if you had objected to the claim as untimely and they had moved to strike your objection, that would be a different order. I don't know that it, you know.
And we did object. But by the time she had issued the order, our time to appeal what we felt was the motion to strike was going to run. So we appealed the motion to strike.
Okay, but the order, well, you appealed the order, but the order
Right.
was the order was denying your motion to strike the claim, right? Okay. And so if that doesn't fall under this, and I know you assert it does, but if it doesn't fall under this, is there some other basis that we would have jurisdiction here?
I believe that we could go back to the lower tribunal and seek a hearing in front of her on our objection to the claim,
Okay.
and then we might come back here again.
Thank you.
I will proceed then. In the 2015 case, Jones v. Golden, decided by the Supreme Court of the state of Florida, they specifically state that the creditor's claim period begins upon the date of first publication. That in itself suggests that it does not begin the day after the date of first publication. And in my research, I found 17 cases in which the court lays out the date of first publication and does not state a day after the date of first publication to measure the creditor's claim
But
time
counsel,
period.
given that section 733.7021, which is the statute in question here, does not specify whether the computation of the 3 months should include the date of first publication, why isn't Rule 2.514 applicable to its application?
Specifically, in the Florida Rules of Probate published by the Florida Legislature, directly beneath 733.702, it does mention a specific statute to compute the time, and that is statute 95.031, which is the statute describing statutes of limitations and when their time begins to run. In that statute, it states that when the cause of action accrues is when the time for statutes of limitation begin to run. And in Florida, since the 50s, the Supreme Court has considered section 733.702 to be a statute of limitations.
So is it your position that 2.514 would never apply? Of course, notwithstanding the argument, it doesn't apply at all because it's a statute of limitations. But if we were analyzing 2.514, is it your position it never applies if, in fact, a rule or statute mentions any time limitation?
It is my position that 2.514 does not apply to the 3-month creditor's claim period. I have not seen it applied, and
But my question is, if there's any mention of time computation in a statute or rule, is it your position 2.514 never applies if there's a mention of a time calculation, or that it will apply if ambiguous?
I would say that it's my position that it does not apply. I think that the case law backs that up, and that in my research, I was unable to find a single case referencing Rule 2.514 with 733.702. And even after 2.514 was adopted by the Florida Supreme Court in 2012, in the Jones v. Golden case in 2015, they specifically said time begins to run upon the date of first publication, which to me suggests that it would not begin to run the day after.
Right, and I understand that, but that's not my question. My question is, do you interpret 2.514 as applying only when a statute or rule fails to mention any time calculation at all, or does it also apply if there's a mention of time computation but yet ambiguous?
I think the first of what you said. I don't necessarily think that ambiguity, I think that lack of a mention of any time computation method would cause it to apply. But in this case, 733.702 has cross-referenced beneath it the time computation method for statutes of limitation, 95.031.
I think you're getting to this. Were you to find any case law that applies Rule 2.514A1A to exclude the day of the triggering event in computing when a statute of limitations begins to run?
Could you repeat the question?
Were you to find any case law that applies Rule 2.514A1A to exclude the day of the triggering event in computing when a statute of limitations begins to run?
That's correct. I was unable to find any case law specifically connecting 2.514 to the 3-month creditor's claim period. I did not search outside the scope of probate. But I do think that public policy favors the interpretation that the courts have seen for the past 30 years, since 1975, when they began interpreting Section 733, 7021. The
Do
point.
you agree that if we were to apply Rule 2.514 in computing the statutory 3-month period, appellee's claim would be timely?
I agree that if you begin counting on January 5th and you make the 3-month creditor's claim period 1 day further to April 5th, the claim would be timely. However, the creditor's claim period based on the case law begins on January 4th and ends on April 4th, making the claim untimely and barred as a matter of law.
Thank you.
If there are no further questions, I would like to put the remainder of my time away to respond to the appellee.
Thank you, counsel.
Thank you.
Good morning. May it please the court. My name is Boris Galostov, and I'm appearing on behalf of the appellee. In 2012, as the court is aware, the Florida Supreme Court enacted Rule 2.514 with the express purpose of bringing uniformity to the time periods described in various statutes, rules of procedure, and even court orders. It replaced similarly worded statutes that were enacted prior to that, and these would include Florida Rules of Civil Procedure 1.090, which provided a rule for computation of time prior to the enactment of Rule 2.514, as well as Probate Rule 5.042, which did the same thing. Both of those rules were amended in 2012 in accordance with the Supreme Court opinion to reflect deference to Rule 2.514.
Counsel, will you already find any appellate court decisions applying Rule 2.514 and interpreting Section 733.702?
Not specifically on point, Your Honor. However, I did find case law that in probate cases dealt with the question of objections filed by personal representatives to statement of claims that are timely filed. And I've got two cases dealing with that issue. I got Greer v. Estate of Smith, 342 Southern 2nd, 1007. This is a 1977 4th DCA case. And this specifically applies Rule 1.090, which is the civil procedure rule that is the predecessor of Rule 2.514, and it very clearly states this: upon a reading of the statute and the rules together, considered in the light of the foregoing authorities, we have no difficulty in holding that Rule 1.090E, in this case it dealt with the provision having to do with filings, deadlines that fall on weekends, which is also part of the Rule 2.514. It's subsection C. We're talking about subsection A. But it clearly applies it and says must be deemed cumulative to the statutory procedure describing time limits for filing of suit after service of objection by mail. So this is a case that deals with the second step in the procedure that we're engaged in, where a statement of claim is timely filed, and then the personal representative has 30 days to file an objection to that claim. And clearly this case renders the predecessor to Rule 2.514 as applicable and is starting the period on the day after.
Counsel, will you find any case law applying the procedural rules prior to the filing of the cause of action?
I'm sorry, Your Honor.
Will you find any case law applying the procedural rules prior to the filing of the cause of action? The case you just mentioned referenced after the cause of action has been filed.
Yes. If we're talking about the statute of limitations, which is appellant's other argument, and I think that that's an important argument to address, yes, I did find case law that applies to statutes that makes the predecessors to 2.514 applicable to cases involving statutes of limitations. So, for example, this is a 1950 Supreme Court of Florida case, McMillan v. Hamilton. This was a tort action, so not probate. However, this discusses specifically a statute of limitations, and it states, is the suit barred by the statute of limitations? And the court says, the general rule for the computation of time accepted and recognized in this jurisdiction is that where an act is to be performed within a specified period of time, the first day is excluded in the computation and the last day of the period is included. So prior to the implementation of this rule, this was the view of the Supreme Court, that it would be the day after. So the rules of computation of time, and I think this is the crucial thing that the court, I think, needs to accept, is that these rules operate as a complement to statutes, other rules of procedures, and orders.
But counsel, section 733.7021 is a statute of limitations, and section 95.031 requires the running of the limitations period from the accruing of the cause of action.
That's correct.
When did the cause of action accrue in this case?
Your Honor, I believe that both of those statutes, 95031 and the statute that we're here under, 73302, both of them would still be subject to the rule dealing with computations of time. Even the statute of limitations statute, to the extent that it does not specify a way of computing time, would be subject to the rule of administration.
So, Civil State Counsel, my question is, when did the cause of action accrue in this case?
Well, so again, Your Honor, the court views it as a statute of limitations per some of the case law that appellant mentioned. But it's not like a pure statute of limitations. If the court is asking me
There's
when...
no cause of action here. I mean, the claim accrued at the death, right? Which was long before. The claim against the estate accrued when the person died, right?
Right.
So it's not something that
But again, statutes of... So whether the statute of limitations states that it is to be filed after the... if it's to be filed within 3 months after the date of publication, that still does not provide any kind of computation of time. We have an idea...
When we're talking... Well, first, I wonder if you could step back and address the jurisdictional argument that I was talking to your opposing counsel about. Do you agree that we have jurisdiction to hear this non-final order? And if so, what is that jurisdiction? Where does that jurisdiction come from?
Well, as far as the jurisdiction, I don't think we made any...
Well, I know you didn't make an argument that we don't, but we have to decide that, right?
Yes, Your Honor. I think I would defer to the court whether the court has jurisdiction to hear this case. But again, I think that the crucial thing here that the court needs to take away is that the rules for computation of time they're not substantive rules, they're procedural rules. And they apply regardless of what the statute itself says, unless the statute contains an alternate way of computing time.
Well, let me ask this. I'm not convinced 2514 applies at all because we're talking about computing time periods, and I think there's a difference between saying such and such must be done within 30 days, an answer must be filed within so many days, versus here the statute says it gives you the deadline on or before the date that is 3 months later, and maybe that's too precise, but my question is, if it does apply, it gives these details, and you keep talking about the first one, which is 1A, begin counting on the next day. But the next one says count every day, including intermediate Saturdays. So how do we apply the count every day when we're talking in periods of months here? And the reason I ask that is because I think if the thing said you had to be filed within 1 week, or that'd be a Wednesday to Wednesday, I think you would agree with that. You wouldn't say Wednesday, you get to the next Thursday, would you?
Well, no, you would still not count the first day according to this rule.
But you would count in days. So if it were a Wednesday, you'd start the next day. So Thursday would be 1, right?
Right.
Friday, Saturday, Sunday, Monday, Tuesday, Wednesday, back to Wednesday. And so here, I think you've kind of got to deal with the fact that we're talking about counting days.
Yeah, absolutely.
And so I wonder how you would address that. I mean, I totally understand your argument that a month is not always measured in days. They're not all the same.
The case law is actually directly on point. You count when the time period is described in months. You count from that day to the next day of the corresponding month.
Okay.
But
that's not what this rule says, because it's talking about counting every day.
Well,
and
again,
I realize the lead into that says when the period is stated in days or a longer unit of time, and certainly a month is a longer unit of time.
Right. Well, this rule doesn't necessarily address that, because we've got statutes of limitations or statutes that prescribe the amount of time that somebody has to complete a specified act. But the way to compute the days, that's where this rule comes in, okay? So this is supposed to be read as a supplement to all the case law. So we're not rejecting that the statutes that counsel is arguing from say what they say. They do say within 3 months after the first date of publication. It does say that. But that begs the question, when is that first date to count? And according to the rules of procedure that have been in place prior to 2.514, according to the case law that existed prior to that, and according to 2.514 itself, we are not to count that first day. So in this particular case.
Going back to my question again, counsel, regarding when the cause of action accrued. Appellees filed a statement of claim against the estate in the proceedings below. Is that correct?
I'm sorry, Your Honor?
Appellees filed a statement of claim against the estate in the proceedings below.
Yes, Your Honor.
When did the appellee's statement of claim against the estate accrue in this case?
So I would say, well, I don't know, because the statute of limitations that deals with accrual does not deal with the starting day, Your Honor. In order to figure out when the statute of limitations period begins to run, we have to look to Rule 2.514. It's just like we can't force people.
But didn't the claim, I mean, the legal right that she's asserting to proceeds in this estate accrued upon the death, right? I'm not saying that's when the clock started. I'm just saying that's.
Yes.
We're talking, so
Yeah, if we're
talking about
talking-
accrual of claims in this context is not quite the same as talking about the accrual
Exactly
in a
right,
slip
Your
and fall
Honor.
case.
The difficulty is arising as a result of the court's usage of language to refer to the claims period as a statute of limitations in some of the cases that the appellant has brought forward. But
Right, you're saying when the Supreme Court says this is like a statute of limitations, they're not saying that that the statute of limitations statutes apply, and so we're not talking about when the cause of action accrues, because we're not talking about
I'm arguing that whether or not the statutes of limitations statutes apply, they very well may apply, but they're all subject to the rules of time computation set forth in 2.514. And look, Judge, subsection C of this, literally, if it didn't apply, people would have to be filing things in court on Saturdays and Sundays. Because I'm assuming if subsection A doesn't apply, then subsection C wouldn't apply to statements of claim.
Well, but you're saying B doesn't apply, right?
No, I'm saying all three apply.
Well, how do we apply B then? How do we apply B if
Because
it applies here? It says count every
B
day.
is triggered upon satisfaction of A. So A determines whether the period begins tolling the day of or the day after.
Mm-hmm.
B refers to what days you count as they go forward. So you want to count the weekends because you're counting calendar days. Subsection C addresses the end of that time period, where if it falls on a weekend or a federal holiday, people can't be expected to break down the doors of the courthouse to file their notices of claim.
But when we're counting days, do we take into account the fact that, I mean, are we counting days? So if it's February 15th, do we count 28 days from there?
It depends, Your Honor. It
Okay.
depends. The computation rule refers to all time periods stated in days or greater.
Right.
Okay? In
This-
this
and this is-
particular
this-
case, we're dealing with a time period stated in months.
Correct.
There is plethora of authority on how you measure that time period. That time period is from that day of the month until the day of the until the same day on the corresponding month.
That's what other authority says, you're saying, but this talks about, so how do we count every day in this instance is my question? Or do we just skip over B and just apply A and C?
No, Your Honor. Well, why would I'm not following as to why B wouldn't apply in this context.
Well, you're saying you just go straight from 1 month. So February 15th, do you count 28 days? Do you count 30 days? Do you count 31 days?
Count every day?
Yeah.
Okay.
Or do you just say February 15th plus 1 month equals March 15th? And if you do that, when I'm not saying that's not the right answer, but if you do that, it seems like we're disregarding the count every day, including Saturdays, Sundays, legal holidays, et cetera.
I mean, I think that's an interesting point that the court makes, and maybe the rule itself requires some further clarification as to, because it appears that B specifically deals with time periods stated in a number of days, does not deal with time periods stated in months, as is the case here. But there is no question that the bulk of the authority has defined time periods that are stated in months as beginning on one date of the month and ending on the corresponding date of the end month.
Okay, and going back to the 702 language, your position would be where it says the date that is 3 months, that's your deadline, the date that is such and such would be the same as within, you must file within 3 months? I mean,
Well, again, I don't think that the crucial issue here is what the end date ends up being. The crucial issue is when do we start counting.
Well, I guess the crucial issue for 2514 is whether this is something where we are computing time periods versus just looking to what the deadline that they've established. And maybe that's maybe that's the same thing. But to me, there's a difference between saying you must do such and such within 30 days and saying you must do such and such before the date that happens to be 30 days from today.
I mean,
Maybe that's
Your
not-
Honor,
maybe
I
that's
would
not
say,
different.
look, this rule applies to even court orders. I think if a court order says something is to be done in days, this rule would still apply. It would still start the day
Well,
after.
it's clear that with court orders, if you give a date certain, so sometimes we issue and say, you must file a brief within 10 days. Sometimes we say you must do it by, January 20th, and then, January 20th.
Right,
is the
if it's
day.
time certain, but if it's within 10 days, I would say that that rule applies, and it starts to count the day after. And when it's a period in months, I have no trouble applying the case law that measures that period in months.
So, Counsel, let's assume for the sake of argument that we agree with you, and we're inclined to affirm the trial court. What case authority can you give us to support this position?
What case law, Your Honor?
Yes, to support the position.
Well, again, the case law that I've cited earlier, so I've got 3 cases here. 2 of them are probate cases that again, none of this stuff is on point, Your Honor. This is a relatively new rule. It seems to be.
You may answer the question.
Okay. So the 3 cases that I have that I wanted to bring to the court's attention is Greer v. Estate of Smith, 342 Southern 2nd, 1007. This is a 1977 4th DCA case, and this applies the predecessor to Rule 2.514, the Rule of Procedure 1.090. Okay? The next case is Public Health Trust of Dade County versus Gabrilov, and that is 349 Southern 2nd, 1228. It's a 1977 3rd DCA case, also dealing with the period of time to respond to properly filed statements of claim. And the last is McMillan v. Hamilton, which is a 48 Southern 2nd, 162. This is a 1950 Supreme Court of Florida case dealing with a tort issue that specifically makes Rule 1.090, again, the predecessor to Rule 2.514, specifically applicable in statute of limitations cases. And this is specifically to address the appellant's argument regarding statutes of limitation.
Thank you, Counsel.
Thank you, Your Honor.
May I begin?
You may, Counsel.
Thank you. I would first like to address that in the appellee's argument, there was a lot of talking about days, but the statute 733-702 is specifically measured in months. Whether some months have fewer days than other months is part of the calendar, and that is something to take into account when the personal representative is first publishing the notice to creditors.
If the 3rd month ends on a Saturday or Sunday, then what happens? Would
Well,
they get till Monday?
Judge, I would say that you don't have to wait until the last day of the creditor's claim period to file your claim.
Suppose the last day is a Saturday or Sunday and you file Monday. Is that timely?
I don't think that's timely, Judge. I would say that if you publish the notice to creditors on the first day of the month, you get until the first day of the month 3 months later. And cases support that. 17 cases, more than 30 years of case law, where each district court in the state of Florida and the Supreme Court have said that upon publication, for example, in Spore v. Berryman by the Supreme Court said that the personal representative published the notice to creditors on January 9th. The 3-month creditor's claim period ended on April 9th. Second, actually, I think I addressed everything I wanted to right there. Does the court have any further questions for me?
Thank you, Counsel.
Thank you.
Thank you, Counsel, for your respective oral arguments. As I said beforehand, now we will remain on the bench for a question and answer session from the students from the University of West Florida.